Please be seated. The court is now in session. Mrs. Chakraborty, could you report the attendance of the parties and individuals to the proceeding? Chakraborty, good morning, Mr. President. All parties are present except the accused Ieng Sari, who is present in the holding cell downstairs. He requests to waive his direct presence through his counsel to participate in today's proceeding. And the request is for the whole day proceeding, and the letter of waiver has been submitted to the greffier. As for the next witness, TCW 307 is present and waiting to be called by the chamber. Thank you. Thank you. The chamber will now decide on the request by the accused Ieng Sari. The chamber has received the request by Ieng Sari dated 6 September 2012 through his counsel to waive his direct presence in today's proceeding and instead requests to follow it through a remote means for the whole day. Kui Samnang, the treating doctor, has examined the accused this morning at the ECCC detention facility and observes that Ieng Sari is fatigued, feels dizzy, and has backache, and recommends that the chamber shall authorize him to follow the proceeding through a remote means from the holding cell downstairs, and as Mr. Ieng Sari himself requests to waive his direct presence due to his health, and as observed by the treating doctor, but that he is fit physically and mentally to follow the proceedings through a remote means from the holding cell downstairs, and that he is able to directly communicate with his defense team, the chamber grants the request by the accused Ieng Sari to waive his direct presence in the courtroom and authorized him to follow the proceeding through an audio-visual means from the holding cell downstairs, and that applies for the whole day proceeding. AV unit, you instructed to link the proceeding to the holding cell downstairs so that the accused Ieng Sari can follow it. The chamber would like to give the floor to Nuon Chia's defense to continue putting question to this witness. You may proceed.
Thank you, Mr. President. Good morning, everyone, and good morning to you, Mr. Witness. I hope you had a restful evening and a good night's sleep. Before we continue with the questioning, I have one point I'd like to raise. For the record, Mr. President, I did take you up on your suggestion yesterday, and I had a look at Rule 76.7, as you suggested, and that rule states, subject to any appeal, the closing order shall cure any procedural defects in the judicial investigation. No issues concerning such procedural defects may be raised before the trial chamber or the Supreme Court chamber. Now, first of all, I'd like to say that the kinds of things we've been talking about, that is the Nuon Chia defense team, the kinds of things we've been complaining about, quite frankly, are not the kinds of things that anyone could reasonably describe as procedural defects. What we're talking about are fundamental fair trial issues. What, if my memory serves me correctly, in the United States we refer to as substantive due process rights. Not to mention that these issues go to the credibility of any witness before this chamber. So if you permit me to give you a hypothetical example, and I'm not suggesting that that this has been taking place, but let's just say that in the midst of a hypothetical civil law trial, it was discovered that a particular investigator had paid certain witnesses to give testimony. If that fact came out during the trial. Now, I don't think any judge, civil law or otherwise, would consider that to be a procedural defect. That's clearly something that goes to the substance of the evidence, something that should be discussed at the trial stage. Now, again, I'm not suggesting that that kind of thing has been taken.
President, if I am not mistaken, this morning I hand the floor to Nuon Chia's defense to put questions to this witness. That is my instruction this morning. The floor is not given to you just to make your free speech as you wish. You raise the issue of the seriousness regarding the question-answer session yesterday, and we already ruled on that issue. The Chamber also informed you of this matter, and if you consider the matter is of a serious nature, you shall submit it in writing to the Chamber with sufficient grounds. And the Chamber also reminded you to consider the relevant internal rule, that is Rule 76.7, which clearly states that except that it is the subject of the appeal, no procedural defects can be raised before the trial chamber or of the Supreme Court chamber. That is just an indication to the internal rule for your consideration for the submission. We already ruled yesterday regarding the objection by the prosecution of this witness. And the sole purpose was not to delay the testimony of this witness for weeks. And for that reason, you shall submit your request in writing. And if you do not have any questions to be put to this witness, we will hand the floor to other defense team in order to expedite the proceeding.
Thank you, Mr. President. I'm well aware of the limitations on freedom of speech in this courtroom. I was simply replying to your suggestion to consider Rule 76.7. I do.
We give the floor to you to put questions to this witness. And if you intend to submit your request in writing regarding the matter you raised yesterday, you should do so. And you should consider all the relevant documents before you make such a submission. You also reminded of the relevant internal rule as you raised yesterday. Once again, as I repeat, if you consider the nature of the matter is of a serious concern, then you should consider the relevant rule and make a submission. And we also indicated the relevant rule to you, and that matter does not apply to the question-answer session with this witness. And you just cannot use the opportunity to make your speech or raise your concern which is not relevant to the instruction by the chamber to you, that is to put questions to this witness.
Thank you, Mr. President. Again, good morning to you, Mr. Witness. I do have a few more questions for you today. Hopefully it won't take too long. I suspect that I will finish in about an hour, certainly before the morning's coffee break. And I will endeavor to speak very slowly for my friends in the translation booth. Let me first start with an issue that was raised yesterday by my colleague, Major Sanarun. And again, Mr. Witness, I don't mean to bombard you in any way myself with repeated questions. I'm just trying to get a bit of clarity for the record and for our own position on this side of the stage. So if I could just return to something that Major Sanarun discussed with you yesterday, and this is regarding Nguyen Chia's position with the People's Representative Assembly. And before I get to my follow-up question, let me just clarify, for your sake, for the record's sake, and for everyone's sake, that Nguyen Chia has never denied his position as chairman of that assembly. He did hold that position. He has said so on many occasions, and he stands by that position today. And let me just add that he is in no way ashamed of having held that position. Now, turning back to my colleague's question from yesterday, which I believe, if memory serves, was along the lines of, how could you, Mr. Witness, how could you be so sure that Nguyen Chia was, as you suggested several times, responsible for the people? That was the question that I believe was asked. Now, I'd like to first, before I put my question, I'd like to turn to what you told one of the civil party lawyers on Tuesday of this week. And again, it's probably best if I quote from the draft transcript, so you can correct me if I'm misstating your evidence. And I'm quoting now from Tuesday's transcript at pages 56 and 57, when you, quote, when you were questioned on those documents by the co-investigating judges, and you were asked why Nguyen Chia was copied, and you said that, quote, Nguyen Chia was in charge of the service relating to people, end quote. Could you please explain to the chamber exactly what you meant when you said he was, quote, in charge of the sector relating to people? And this is, I'm still quoting the civil party, this was their precise question, the civil party lawyer. What were precisely his responsibilities, Nguyen Chia's responsibilities? And your answer was, it was a public announcement that Mr. Nguyen Chia was attached to the People's Representative Assembly, and he was also the chairperson of that institution. So, as the people's representative, he shall know whatever matters that are relevant to the people, and he was at the supreme body to be in charge of all matters relevant to the people as he was representing them. Do you remember making that, giving that answer, having that exchange with the civil party lawyer on Tuesday?
But yes, I recalled my statement. I knew or learned of that through an open announcement. However, when it came to their internal affairs or internal arrangements concerning Nguyen Chia, I did not have that knowledge. I spoke or I stated based on what I understood, as he was with the People Representative Assembly. It means he represented the people. Therefore, whatever was done at the best, which may have an impact on the people, he would be the representative, the supreme representative, who had to know all those matters and to defend the people. And this is based on my understanding. I did not know that the standing committee assigned him to represent the people. I did not have that knowledge. I only made my statement based on my understanding. And he's not the people representative. He, the one who was in charge of the people throughout the country. So whatever matters that concerned the people or their well-being, he shall have such knowledge. And that is my personal opinion.
Thank you, Mr. Witness. And let me go back to one of the first points you made about this public announcement. That public announcement, what did that public announcement say precisely? Did it simply announce that Nuon Chea was in charge of the People's Representative Assembly?
What I knew publicly was that I listened to the Democratic Cambodia radio broadcast while I was working. So then I could learn about the situation regarding the development in the country. I cannot recall the exact year. However, I believed it was in 1976. There was a meeting by the Assembly, which was their first legislature, the first session, and they announced who were appointed in a specific position, who was the president of the state presidium, who was the prime minister or the first or second deputy prime minister, so on and so forth. That's how I learned of that. And the same thing applied to the People Representative Assembly. They announced that for the People Representative Assembly, Nuon Chea was in charge. And as for the court, it was Kong Chap who was in charge. And for the state presidium, it was Mr. Khieu Sampon who was the president. I did not see this announcement in writing. However, that's what I can remember. And it has been more than 30 years, so I cannot remember all the details.
Thank you, Mr. Witness. That's fine. Just one last question on this point. When they mentioned Nuon Chea was the chairman of the People's Representative Assembly, as far as you remember, did they say anything else, or simply that he held that position? If you remember.
I cannot recall further than that, and I did not know as well.
Thank you. Thank you very much. Moving on to another topic. A particular telegram, this is telegram 54, has been discussed quite a bit since you've taken the stand. I don't want to ask you any substantive questions about that telegram, but just for everyone's benefit, I'll just note the document number for the record. It's E3/513, and that's telegram 54. We've been discussing it. I think everyone's familiar with it. If you recall, Mr. Witness, that is a telegram that dealt with, among other things, an alleged immoral act with a woman by someone called Sot. And so I just have a few questions about what you told the OCP here in court with respect to that document. Do you remember discussing that telegram? That one about Sot?
Yes, I can recall that.
Thank you. And again, just for the sake of clarity, I think it's a good idea if I quote from the transcript. This is the draft transcript, Monday's draft transcript. That's the 3rd of September, and I'm at pages 27 to 28. And I'm quoting now the question. When you were asked about why this type of telegram would have been sent to Nuon Chea, you said anything involved with the internal situation and the violation of moral codes, they had to contact Nuon Chea because Nuon Chea was related, because Nuon Chea was in charge of the people. Is that an accurate summary of your statement, Mr. Sopong? The telegram which dealt with violations and the internal situations would be sent to Nuon Chea. And your answer was, at that time, I was not able to know this because Pon was the one who oversaw all of this. But you asked me to help analyze on this, and based on my knowledge, the reason the message had to be sent to Nuon Chea because he was in charge of social affairs and culture. So when it comes to the violation of moral code, it should be Uncle Nuon Chea who would be the person whose the message was sent. That's my analysis. End quote. And now, with respect to this passage, I'm particularly interested in what you've referred to as your analysis. So my first question is, would you agree that analysis that you did for the OCP was done after the fact, that is, much, much later, at a time after you were engaged as a DK telegram coder? Is that correct?
What you just described is correct. And in regards to my response to the co-investigating judges, I myself was not sure whether the message had to be sent to Nuon Chea. But because I saw the annotation which reads Uncle Nuon, then I offered my opinion to the OCIJ investigators that, based on my analysis, the message was sent to Uncle Nuon because the content of the message was related to the morality issues, and that matter was also related to the People Representative Assembly, who had to know about all these matters, about the violations, because just one individual person was also part of the people and the care of the People Representative Assembly. And that was my analysis. And if the chamber is of the view that my personal analysis cannot be considered as evidence, then I agree that that analysis shall be dismissed. And I would like to make this statement before the chamber, because if you believe that it is my assumption or a speculation which is not the truth, then please disregard it.
Thank you for that answer, Mr. Witness. And just to be very clear, this particular assumption is based on two things: Nuon Chia's title and the fact that Uncle Nuon is written on that document. That's the basis for this assumption that you've made. Is that correct?
Yes, that is correct. Because I clearly saw the annotation mentioning Uncle Noon and nobody else but him.
Thank you very much for that clarification, Mr. Witness. I will turn to another topic. Yesterday morning, Mr. Witness, if you recall, Judge Lavergne took you through a number of telegrams covering a sort of a potpourri of topics. Do you recall that? That was yesterday morning? I think it took the first part of the morning before the coffee break.
I am not that well, so I cannot recall at what times questions were asked to me. So please ask me direct questions.
I apologize, Mr. Witness, and I apologize for not asking earlier this morning if you were well. Are you feeling all right? Are you able to continue?
I am able to, but please state your question clearly. And please ask me a direct question so that I can respond appropriately.
I will do that. Judge Lavergne is the gentleman sitting 2 spaces to the right of the President, and yesterday morning he discussed a number of documents with you. Do you remember that exercise? That's my first question.
Which judge are you referring to? A foreign judge or a Cambodian judge?
Indeed, a foreign judge, a French judge, Judge Lavergne. He's wearing glasses and sitting 2 spaces to the right, to your right, of the President. He's a very tall gentleman.
Yes, I recall the exercise, but I could not recall every detail of that exercise. And if I may suggest to the court, it will be very helpful for me if the court officer can prepare documents for me, because if you see the documents, a pile of documents before me, I can hardly distinguish which was given by whom here, so I can hardly distinguish. So, the President. Well, Mr. Witness, if you cannot recall or remember, then you can say so. You do not have to dwell on it. First, you may simply respond to the question whether or not you answer to the question put by the judge. Of course, if you ask about the documents that were presented to you, I don't think that anyone in this courtroom will recall every single document we have given to you. So you simply say so if you cannot remember. The witness. Thank you, Mr. President. I do not recall everything.
Neither do I, Mr. Witness. Neither do I. You did answer some questions on these documents, and I'm not really interested in the substance of them. It was a series of, I think, about 10, maybe a dozen documents, as I've said, and each one was a telegram. And as Judge Lavergne was discussing those documents with respect to each telegram, he mentioned that Nuon Chia, among others, were copied on those documents. Do you remember that? It's fine if you don't.
Concerning the carbon copy for others, normally in almost every document there was a copy for Ankol, and Ankol Nuon Chia would come first. After Ankol number 1, Pol Pot, and then Ankol Nuon, followed by Ankol 1. So it had to be in order. So the order of Ankol 1 could not come before Ankol Nuon, and Ankol Nuon's order was not above Ankol Pol Pot. And as I told the court yesterday concerning the carbon copies of the document, they had to copy to Ankol, who was referred to Ankol Pol Pot, and followed by Nuon Chia, the second in the order, and followed by Ankol Van and Von. Q were in the orders. These were the orders of people whom the telegrams were copied to. And then last on the list was the documentation and archive. And that's what I have explained in this court so far. I don't know why you were not clear with this procedure.
Thank you, Mr. Witness. I sometimes have a hard time getting head around things. Thank you for clarifying that. The question I wanted you to ask you was based on what you told us yesterday about the limits of your knowledge. And do you recall that conversation that you and I had about the limits of your knowledge? That would be my first question.
Yes, I do admit it. You may be well aware that at my level I was supposed to know the general information like other people in the world would know about that information. I did not understand the internal working arrangement of the standing committee.
Very well. Very well. Thank you, Mr. Witness. I'll just leave off on that for now, possibly come back to it. I'll move on very quickly to another topic. And now I'd like to discuss particular transmissions to and from Nuon Chia, or at least your testimony about some particular transmissions to and from Nuon Chia. The first transmission I'd like to discuss regards something you said to the civil party lawyers on Tuesday. Based on what you told them and what you told my colleague Major Sonaroon yesterday, during your tenure as a telegram coder, you only dealt with a single message from Nuon Chia, and that was a 1977 invitation to a meeting of the People's Representative Assembly. Is that correct?
Yes, that was the case once. And there was another instance, I do not recall the exact date, but at that time, Cambodian people were suffering from either a drought or flood or so at that time, and then the upper authority issued a directive for us to prepare telegrams to give instruction to address the food shortage issue. And at that time, the local authority were facing natural disaster. And in that directive, there was a signature by An called Nguyen. That was the only case I saw.
Thank you, Mr. Witness. If we could stay with that for a moment, just so I understand it. There was a problem with flooding, I think you said, at the local level, and the leadership wanted to address this problem, to solve this problem somehow, and Nguyen Chia's signature was on the document. Is that correct? Is that what you've said?
It was not meant to address the issue of flood, but the flood had devastated the crops of the people in one of the locations. So he provided a recommendation for the people in order to address the aftermath of the flood. For example, he encouraged people to plant crops, and he also urged the cadres to go to see the people and encourage people to replant crops and things like that. So these were the recommendations from him, and there was a signature on that document, and it belongs to Nguyen.
Thank you, Mr. Witness. I'll just move on to my next point. Based on this, and now I would like to discuss a particular communication to Nguyen Chia. And again, based on what you told the civil party lawyers on Tuesday during your time as a telegram coder, I believe you said that you only saw one telegram relating to so-called moral offenses. And again, I'm referring to that telegram 54, the one that dealt with Sot. You said that was the only instance of a moral offense that you dealt with. Is that correct?
But
at the sector level under Sarun, he reported only that instance. And as for other telegrams, there was no reports to that effect.
Thank you very much. And now, if we could turn perhaps to one of your statements to the investigators, and I have 2 or 3 questions about that, and I'm referring to document E3/67, and that's the written record of the interview you gave to the OCIJ on the 28th of March, 2009. And we've been discussing this document over the course of the last several days. Do you remember this document? Do you remember this interview we discussed? This was your second interview.
No, I do not.
Let me then refresh your recollection and just simply read from a portion of this interview. And I'm referring now, again, that's document E3/67. That's the OCIJ interview of 28 March 2009. And I'm on English page 8. That's English ERN 00483970. Khmer ERN 00294542, and French ERN 00374937 through 38. And allow me to just read this out, Mr. Witness. This is your answer in response to a question put by one of the investigators. I did not know whether or not each location had made reasonable reports in accordance with the actual situations, because some telegrams reported that the living standards of the people have become better. But actually they did not know that the people ate porridge. I did not know. I heard from my friends, after they had gone home and returned, that they were very sorry to see that the base was poor and deficient, that their parents did not have enough food to eat. But when one listened to the radio, it was broadcast that our country had plenty and was joyful in the great leap forward. In the democratic Kampuchea time, I also listened to the broadcast while working. I was so very happy to hear that the people had better living. There were canals linking with each other, but the fact was different from what the radio was broadcast. Sometimes someone wanted to have good face for himself. He just reported very good, very good. But some places had made true reports as well. Do you remember giving that answer to the OCIJ investigators?
Yes, I do, and I stand by this statement.
Thank you. Now, if I could just ask you one or two questions about this. It seems to me from reading this passage that you yourself, in the telegram office during the DK period, didn't have a true or a clear understanding of what was actually happening at the bases, and that was in part because reports coming from the bases were not correct. Is that true? Is that an accurate summary of your position?
I have already told the court that I did not have any idea whether or not the situation that evolved at the basis were true or not. But I asked my colleagues who came to visit their homes. They told me that in certain bases there were good leaders and they had sufficient food to eat. But in other places, the leaders were not that good and people had to eat porridge. That was the reality that reflected the situation at the time.
Thank you, Mr. Witness. And just one more question on this point. Let me repeat what you said to the investigators. Sometimes someone wanted to have good face for himself. He just reported very good, very good. Could you just explain a bit what you meant by that particular sentence? Someone wanting to have good face.
It means that people want to claim their credit. They wanted to be promoted. For example, if they were at the sector committee, they wanted to be promoted to the zone committee or to the central committee or standing committee, then that is the greed of certain individuals. So they simply wanted to claim credit for themselves. It was not the clear or totally accurate reflection, because it was based on my analysis. Because I look at certain reports, they say that the rice production yield was up to 3 tons per hectare. At other places, there were 5 tons per hectare. In other reports, they also mentioned that 10 metric tons of rice production yield per hectare. And if that was the case, why people were starving at that time? That was my personal judgment of the situation. And upon hearing your question, in my own analysis, I think that there could have been certain peoples who wanted to claim their credits. That's why they had to underreport of the situation, and they make mention in their telegrams that people were enjoying their life, there were progress made at their location, but in reality that was not the case. Even enough food to eat was difficult for the people, and they did not even have proper clothes to wear. I also noticed that sometimes Angka distributed clothes and materials to them. Mr. Kilsampon was the one who ordered the distribution of materials and equipments, but unfortunately people on the ground did not have access to materials and clothes to wear. For example, if the center sent the sewing machine there, sometimes they were broken and it was under maintenance, so it was not put into good use, and that's why it reflected the miserable life condition of the people, and it also reflected the incompetence of the local authority in leading their own location.
Thank you very much, Mr. Witness. That was a very interesting answer. If I may move on to another question, staying with this document, E3/67, moving to English page 12, and that is English ERN 00483974, Khmer ERN 00294546, and French ERN 00374941. And again, I'll just quote to you an answer you gave to one of the questions of the OCIJ investigators. Quote, on imposing sanction and investigation, the Ankar had instructed not to do harm to the people. But as you already know, when an artillery was fired, sometimes it hit the target, and sometimes it did not hit the target we had set. Sometimes it scattered around. It was inevitable to cause death and injury. So my question to you, Mr. Witness, is do I understand that answer to mean that oftentimes people were harmed by what we would call, in what we would call collateral damage, that is accidental consequences of what you might consider legitimate military activity?
Mr. President, we would object to this question. Unless my learned friend can lay a foundation, we would object. We were instructed and took great care to elicit evidence from the witness's personal knowledge and experiences. And the witness, if I recall correctly, has indicated that he did not go into the bases and nor did he ever observe any military operations. Again, I stand to be corrected if otherwise was the case, but I would invite my friend to first lay a proper foundation, ensure that the witness has direct knowledge of these events, and then continue from there.
I certainly agree with that. I apologize for not doing that first. Mr. Witness, let me ask you again, or let me just repeat a bit from your statement. When an artillery was fired, sometimes it hit the target, and sometimes it did not hit the target we had set. Sometimes it scattered around. It was inevitable to cause death and injury. So my first question, which I should have asked you previously, what is the basis of your knowledge for that statement?
I did explain the court about this issue already. I did not know the truth at the basis, and I did not know whether or not there was artillery fire and killed the civilians. So whatever I said that I did not know, it was my assumption. So I would suggest that the court remove this statement. I think that should be it, and that should be invalidated because it was not the accurate reflection of the truth.
Very well. Thank you, Mr. Witness. And moving on, I think I've got about, just to give my colleagues some notice, I've got about 3 more questions, and then I'll be finished. Mr. Witness, the other day, you mentioned in passing at some point during your testimony that you would be delighted, I think that's the word you used, delighted to come back here into court and to testify about certain foreign perpetrators of crimes in Cambodia. Who did you have in mind when you made that statement?
Again, Mr. President, we would object. We see no relevance.
The President, witness, please hold on. Mr. Prosecutor, you may proceed.
Your Honours, we would object. We see no relevance to the witness's outlook on what other perpetrators may be responsible, what other trials may hypothetically take place, and what evidence he may hypothetically give. It's not an issue that's within the scope of this trial.
My very brief answer would be, if it is within this witness's personal knowledge that certain crimes were being committed during the DK period or shortly before the DK period by foreign perpetrators, then that is indeed relevant to many of the issues that we would like to have debated and discussed in this case. So let me perhaps rephrase the question and see if I can establish the basis of the witness's knowledge and go on from there. Mr. Witness, you mentioned this in passing. Perhaps it's best if you just explain to us what you were talking about so that we know how to deal with that piece of information that you offered. Do you have some actual knowledge about foreign crimes being committed in Cambodia, in this country, either during the DK period or shortly before the DK period?
The President, witness, please hold on. The President, the witness needs not answer this question. This question is not relevant to the relevant facts before us.
Thank you, Mr. President. I'll move on to my next question. Mr. Witness, over the course of these past few days, there's been quite a bit of talk about offices beginning with the letter K, K1, K18, all those Ks on that chart that you prepared for the OCIJ investigators. So while we're on that theme, on the theme of Ks, I would like to know if you, as a Cambodian citizen, are familiar with Operation K5, or the K5 plan, which was implemented in this country not very long after the demise of Democratic Kampuchea. Are you familiar with K5?
Again, Your Honours, with
The President, witness, please hold on. Mr. Prosecutor, you may proceed.
Again, Mr. President, we would object for the same reasons with respect to my learned friend. Events occurring after the end of the Democratic Kampuchea, unless there is a direct link with evidence that Your Honours are now hearing, are simply irrelevant and should not be explored.
Thank you. And as I've said several times before in this courtroom, the issue of whether or not deaths, which occurred on a massive scale, on a rather massive scale, during the 1980s, have been wrongfully attributed to the Khmer Rouge. That's an issue that we've briefed the Chamber on. That's an issue that we've raised time and again. As far as we're concerned, it's obviously relevant. So I think the question is a legitimate one. I have a feeling I know what you're going to say, though.
The President, the objection and the grounds for objection by the prosecutors are valid. This question is not relevant to the facts concerning the evidence we are hearing. Witness needs not answer to this question.
Thank you, Mr. President. And I do have one more question. And Mr. Witness, thank you for bearing with me. This will be my last question. As someone who has specialized in secrecy and ambiguities and enigmas for a number of years, perhaps you can assist me and assist the Chamber as to the particular significance of a phrase that I've been struggling with for some time now. And I've been told, I've been instructed that this phrase is a kind of secret code, that is a deliberately ambiguous use of the language, one that's utilized by certain individuals in positions of power in this country to exert their influence in subtle ways. And the phrase I'm referring to is as follows: "The dogs bark, the caravan passes." Now, I fully understand the literal meaning of those individual words, and I think I can partially grasp the general sense of that phrase. However, I thought, given your background and experience, you may be able to shed light on any deeper hidden meaning that attaches to that expression, especially when it is used by someone, for example, like Mr. Q. Canarit. Would you be able to shed any light on the deeper meaning of that phrase? Now, please don't answer. My friend is on his feet.
Again, Mr. President, we would object clearly.
President, witness, please wait. The prosecution, you may proceed.
Again, Your Honours, we would object. I note it was my friend's last question, so I won't accuse him of continuing to waste time, but clearly the witness's comments about what people may say and what the meaning of those words may be, completely divorced from the Democratic Kampuchea context, are irrelevant and should not be allowed.
For the record, Your Honor, our position, as it has always been, is that the public statements, explicit, implicit, or otherwise, by government officials, which may or may not be attempts to influence these proceedings, are indeed relevant. And they're relevant for the reasons that are already on the record. So I won't take up any more time of the Chamber. That was indeed my last question, Mr. Witness. Thank you very much for bearing with me yesterday and today, and I do wish you all the best. Thank you.
The objection and its ground by the prosecution is sustained. Mr. Witness, you do not need to respond to the last question put to you by the International Council for Known Jia. The floor is now given to Ian Sari's defense to put questions to this witness. You may proceed.
Good morning, Mr. President. Good morning, Your Honors, and good morning to everyone in and around the courtroom, and good morning, sir. My name is Michael Carnavas, and with Mr. Angodam, we represent Mr. Ian Sari. Now, I want to go back to the time when you gave your first interview. And I'm referring to the document that you looked at yesterday. It's, for the record, E3/64. And we can see from the very first page of this document that the statement began on 18 February 2009, and that there was a Cambodian investigator and a foreign investigator. Do you recall that?
Yes, I recall that.
And if we go to the second page, in Khmer, the ERN number is 00328022, going on to 23. French 00411693, and then English it's 00334043. Here we see some boxes, and it says that that you were advised that an audio or video recording was being made of the interview. Do you recall being advised of that?
The box ticks that we advised the witness that an audio or video recording was being made of this interview. They did inform me so, but the audio or video recording did not start first. Only later, when the interview commenced, then the audio recording was started, but they informed me first before it was recorded.
Right, and we can see that the interview began at 9 o'clock in the morning, but shortly we will also play a tape to discuss exactly when the interview began, and I'll be asking you some questions on that. Now, under these boxes, we'll also see that you were advised of your rights. And you were also advised that, or there's one box, that you took an oath before providing the statement. Do you recall taking an oath?
Yes, I recall that I took an oath.
And when they advised you of your rights, do you recall whether they advised you of your rights before they went on tape, or, in other words, before you spoke on tape, or was it after you began speaking on tape?
They informed me of my right against self-incrimination.
Thank you. And just one technical matter. One of the boxes also asks if you know any foreign languages, and you say that you declared that you cannot read or write any languages. Do you recall ticking that box off?
Just to understand a language a little bit could not be used officially. For that reason, I declare that I cannot read or write any other languages.
All right, thank you. So that would explain why later on in your interview you indicated that when you began teaching the children, you were teaching French and English. That you had limited knowledge, but with that limited knowledge, you were teaching the children. But for the purposes of this interview, your knowledge was not sufficient.
It was not about teaching how to speak French or English. The teaching was for them to have a basic knowledge of the Latin characters. For example, which one was letter A or which one was letter B. And English, the word A in French would be pronounced A, etc. It was not a proper language class.
Thank you very much. And then if we look at the very last page of this document, we see that a copy of this was provided to you in writing, and that this document was read to you, and you had no objections before signing it.
Yes, I remember that the statement was read back to me, and after having heard the statement read to me, it was consistent with what I spoke, and after that I signed the statement.
Very well. And we can see the date, that the date is the 27th of March, 2009, which is about 5 weeks after the statement, and 1 day before you gave your second statement. Is that right?
I cannot see when the interview started. President Michael Canavas, the questions that you have been posing to the witness, are they related to any charges against your client?
Well, the witness has testified, and he has given evidence which you are going to be relying on. And in the past, when I've raised issues concerning statements, we have been told by the prosecution that this is the time where we should explore those issues. And yes, it is related to the case. And if you give me another 5 minutes, we will see how. But first, I want to make sure that the gentleman acknowledges that he signed it 5 weeks after he gave the interview. And if we look at his second interview, we will...
The question from the chamber to you: did you ever read these statements during the investigative phase?
You're asking me, Mr. President, did I read them? Yes, I read them. There were thousands of them. But the question is, did I have the time to go over all of the transcripts or all of the tapes? And the answer to that is absolutely not. And the better question is, did the entire bench have the opportunity to read everything? And the answer to that would be no. It's physically and humanly impossible. But part of our due diligence is to explore this area, because the question is his testimony today based on his memory back then, or was it based on events that occurred during the taking of his testimony where he was shown documents? And we will also show that some things he said on tape.
We have two observations regarding the Internal Rule 76, regarding the nullification in sub-rule number 12. During the investigation stage, if any of the parties request to nullify, then it shall be done so to the co-investigating judges by lodging an appeal for nullification to the pretrial chamber. The co-investigating judges may accept or reject the request, and in any cases that shall be done prior to the issuance of the closing order. This is subject to appeal based on the internal rules. And I already read to the Council regarding Rule 76.7 regarding the cure of the procedural defects. And if there is any such procedural defects, those issues may not be raised before the trial chamber or the Supreme Court chamber. And these are the observations made by the chamber. And your question so far seems to lean itself to this part. And the question shall be put to this witness in relation to the charges against the accused. This is just a reminder to you, Counsel.
Well, thank you, Mr. President, but I must take exception, because what you are suggesting is that we do not have the opportunity to challenge the witness's testimony. That's what I'm hearing. You are taking that right away from us. I'm not seeking nullification of the process. Now, one of the other judges may think that that's what I'm doing, but that is not what I'm doing. What I am doing, however, is showing that some things were said to the gentleman on the tape that never made it. Also, we will hear part of the tape where it is acknowledged that he spoke with these investigators the day before. These two investigators are the same investigators involved in another matter. And in fact, one of the national investigators, we now learn, is related to one of the national prosecutors. And so these are the sort of issues that we want to explore. I certainly want to explore what happened the day before. Was he shown documents? How long was the conversation? Why was that initial interview tape recorded? What's the purpose of having a dress rehearsal? If you're going to try to have some transparency, which is the purpose of having...
I think that's it, Counsel. President, Judge Laverne is tasked to take the floor in response to this matter. You may proceed.
Counsel Carnavas, the trial chamber will recall some very obvious facts. The judicial investigation that preceded this trial lasted many years. During the course of the investigation, there were investigative acts that were put on the case file. They were made accessible by the defense teams and by the accused. All of the questions that you've put forward, or that have been put forward to date, are based on the written records of witness statements. All of those indications were entirely accessible by you, as well as by any other defense team representing any one of the accused. The President has recalled at many occasions the rules that govern appeals to procedural acts. We are not discussing the investigation at this point in time. I would also add that as far as the audio recordings are concerned, those audio recordings are obviously in Khmer, and there are no written transcripts, and there is subsequently no French or English translation. Nevertheless, each defense team is comprised of Cambodian lawyers. Each Cambodian lawyer has the ability and power to listen to those audio recordings if he or she wishes. What have the defense lawyers been doing over the course of the many years of the judicial investigation? That is my question. We are here to study and examine issues of substance, issues relating to the judicial investigation must not be subject to redundant and repetitive questions. We have received many written submissions on this matter. The trial chamber will respond in due course, but I believe that we have explored the matter extensively, and we are now ready to move on to the next topic.
I would like to play tape 1, play 4. With the court's permission.
President, Counsel, could you please repeat, as there is no Khmer translation?
Thank you. At this point, I would like to play tape 1, play 4. And what we are about to hear, keeping in mind Judge Laverne's remarks, which, in my humble submission, go to the investigative phase, and I'm not talking about the investigative phase, I'm talking about this gentleman's testimony, and perhaps there's a cultural divide or a legal divide from our different traditions, but I assume that we're here to try to get to the truth. I assume that. But when we play this, we will hear on the tape words to the effect, I would like you to narrate your life story a little bit as you briefed me yesterday. So the day before they went on tape, the day before he was advised of his rights, the day before he was questioned on tape, there was an interview. What documents were shown to him in that interview? How long that interview took place? Where did that interview take place? All those sorts of questions I'm entitled to ask. And if I'm not entitled to ask, I will be making submissions, and I will be submitting also the questions that I would have asked to help you get to the truth, which would appear there's a disinterest on the part of the trial chamber to actually get to the truth, because those sorts of questions are essential in determining what weight, if any, to give this witness's testimony here in court. Because in part, his testimony is on his statements, which occasionally he has to refer to. He's told us on a number of occasions that he disavows what he said. Earlier, he said that he signed it having agreed with the content. Now, if he signed it under oath, agreeing with the content, either he misunderstood, either somebody else put it in there, either it was suggested to him, but these are the sort of things that I'm entitled to explore, and why. Because before you are submissions by the prosecution to hear hundreds of statements in lieu of testimony. And when you pose the question to me, what I have been doing in my team for the last 3 or 4 years, well, let me remind the trial chamber that this was the very first case of this kind in Cambodia, and there were all sorts of legal issues that had to be addressed. Otherwise, we would have waived them. So, and the team that you suggest pales in comparison to the armada, the Roman legion of a team that the prosecution has. So I'm entitled to explore this because it assists you to give weight to this gentleman's testimony. I am not attacking the office of the co-investigative judges, albeit it may seem that way. And yes, my third investigative request, I submitted asking the modalities. How do they interview precisely? What are how do they keep track of exculpatory evidence? What is the template? We never received an answer. Had we received an answer, perhaps we wouldn't be here. But I believe this is a sort of tape that will assist the gentleman to tell us how long the interview took the day before, because I wasn't there. Nobody was there. Only this gentleman was there, and the 2 investigators who were also involved under similar conditions in conducting such an interview.
President, the prosecution, you may proceed.
Thank you, Mr. President. I'll try and be brief, but I think the record needs to be corrected in a number of respects. First of all, my learned friend referred to thousands of statements. Of course, as Your Honours know, that is not true. The initial reference was to thousands of statements. In fact, there were 943 written records filed over a period of 3 years. Certainly not an insurmountable workload for a team of lawyers and support. And let the record also reflect that the resources of the OCP are roughly equal to that of the defence teams. Returning to the issue of propriety of an inquiry that my learned friend is proposing, and if I may I note Your Honour's directives, and I just want to add to the record also, this statement was filed on the 15th of September 2009, several months before the investigation was closed. It was available to my learned friend. Out of those 900 plus written records, a smaller number relate to the acts and conduct of the accused. One would have assumed those were the interviews to which the defence was paying attention, and certainly interviews that would have been of interest to them, as they were particularly to us. Having not raised any of these issues or inconsistencies with the co-investigating judges, having failed to request follow-up investigative action that would have been appropriate in light had the defence considered there to be any inconsistency, they now come before you some 3 years after the interview to raise these issues. They do not come before you in good faith. That is our respectful submission. And let me also say the following. We would agree with counsel that where significant inconsistencies arise, where there is a legitimate question as to the credibility of a witness, we would agree with our learned friends that some latitude should be given to them to explore prior statements and prior transcripts. But what we have heard over the last several days is consistent and compelling testimony from this witness, who has been at pains to stress the accuracy of his responses and to qualify those responses which he thought verged on speculation. It is a question of degree. We would submit that this attempt to falsely create a sense of controversy, which simply is not there, should not be entertained in this particular case. We will always support our learned friends' right to test the evidence, but it is a question of degree, and in this case they have certainly gone beyond that which is legitimate, and we propose that our learned friend should now be directed to turn to alleged inconsistencies in the statements and test the witness's evidence in that manner. Thank you.
The President, the time is now appropriate for the morning adjournment. We will adjourn from now until 10 to 11. Court officer is instructed to facilitate the place for the witness to rest and have him back in this courtroom by 10 to 11. The court is now adjourned.
Soom អញ្ជើញក្រោយជើង